We learned a lot about trademark law during our conversation with Maria Spear Ollis. If you've ever wondered how on earth content can be protected during the absolute age of content sharing, we get into it in this episode. You don't have to work yourself up into a lather worrying about copywriting your material, because we know that as health entrepreneurs, you already have enough on your plate. But it's always good to seek to understand. So see what you take away from this pretty cool and interesting conversation about legal stuff. Hi, I'm Erin Power.
And I'm Laura Rupsis.
We're certified health coaches, and this is Health Coach Radio.
This podcast is about the art, science, and business of health coaching.
We share our insider tips to help you become a better coach and entrepreneur.
And we interview expert guests to discover how they've made it in this growing field.
It's time for health coaches to make an impact.
It's time for Health Coach Radio. All right, Maria, how are you today?
I am doing so great. How are you?
We're doing great. We're always excited to talk about legal stuff. It's what lights all health coaches up, I said, right? Say that sarcastically. But look, I mean, this comes up as a huge kind of bone of insecurity for a lot of health coaches is understanding this. So it's super helpful to have advocates and support around helping health coaches practice legally, covering themselves and some things they need to be aware of. So thank you for doing what you do, because most health coaches are clueless as it relates to this stuff. So tell us about you. Give us your background story.
Sure. I started off as a musician, I'm in Nashville, Tennessee. So many of us here in Nashville started that way. But I was more on the opera and musical theater side, and studied it in college, and then, kind of evolved a little bit. I'll date myself, iTunes was very new then, and like the Napsters and all of that stuff was still in existence. And so I thought, I want to help, the artist, the independent artist, especially, and, fight the music pirates and protect, those creative souls out there. And that kind of led me to law school. Very different from music school. and there, I did some of the entertainment stuff, and I did some entertainment stuff early in my career. But what I really loved was that pure kind of trademark, copyright, creative ideas, and coming up with those ideas and protecting those ideas. And so, when I graduated, like I said, I did some entertainment work, worked with CMT for a little while here in Nashville, worked at another firm, and then went out on my own in 2015. So I've been at it since then.
Wow, cool. That's so interesting. There's so many interesting career paths people can take. And I always think it's so fun to hear how one area of interest and passion just kind of feeds another. It wasn't like going to law school for copyright and trademark stuff was a bummer. You were excited and really interested in it because it was kind of an offshoot of what you like to do anyway. Okay, so you went off on your own, and who were you working with in those early days on your own? Who was your target client?
In my earliest days, it was anybody that needed copyright and trademark help, very wide net, new in business, a little bit of scarcity, but that evolved too. I did, there was a small but mighty fashion scene here in Nashville. So I was doing a lot in the fashion industry after a couple of years. And then that kind of evolved. We did move to Michigan, which is where I'm originally from, for a couple of years. And so then that was 2018. And it was at that point that I kind of wanted to focus on influencers and also, course creators and people who were making a living online pre-COVID, before everybody, that was kind of, the thing to do. And so, because I didn't want to be geographically tied to, Tennessee or Michigan or wherever I was. And so I kind of started in 2018, and that's still kind of that's who I love to work with. I love to work with coaches and kind of your thought leaders and people who are experts in their field that are really, using their knowledge to make an income.
Oh, okay. You got my attention. So, because it's interesting because, course creators. So a lot of health coaches are course creators. We've created a course that our clients get enrolled in, and we kind of consider it as, oh, that's my program. That's just the stuff I take my clients through, but it is intellectual property at the end of the day. Absolutely. And so is your point of view that this stuff should be locked down?
Yes. So, so when we're talking about creative works, quote unquote, we're talking about copyright territory, and everyone thinks about art and music and film and, sculpture when you think about copyright, but it applies to now, especially what is a course? It is video. It is, text to the extent you have workbooks and worksheets. It might be infographics or graphic design. So it's a lot of artistic elements in one package. And so you have some protection in it once you create that, once you publish it and put it out into the world. But registration kind of boosts up that protection. If someone were to take your course content and start their own course and kind of do a ripoff, you could still stop them if you're not registered. You would have to register to file a lawsuit, but that's its own thing. You could still make them stop, cease and desist, whatever. Mm-hmm. But if you're registered, then the law gives you some automatic benefits. And that is, you're automatically entitled to your attorney's fees. So basically it's quote unquote paid for if you go after that copycat. Mm-hmm. And you're guaranteed on the minimum and $750 all the way up to $30,000 in really egregious examples for the infringement that happened. So it's kind of like getting paid to be copied if you have that stuff registered. So it's worth it. I think it's worth it.
Yeah. Yeah. So, I mean, I think I think a lot of health coaches go to market and they build this program. To Erin's point, it's my program, but they don't view that as intellectual property, because many of us are building programs out of stuff we've learned along the way. It's like, it's not my information. I learned it someplace else, but the way you frame it, how it's built, the way you describe it, how it's delivered, all of that is you, mm-hmm. and it's unique to you. And protecting that, particularly as, and maybe this is the question I'm leading up to, at what point in a creator's career should they be really paying much more attention to that level of protection? Because I do want to kind of like back up in a little bit and talk about, people that are entering this space. What do they really need to have from the beginning? And at what point should they be adding on various levels of protection? But starting with that, in terms of coaches that are getting to market, they're building their own program, mm-hmm. do you have a rule of thumb? Is it right away, or is it?
I mean, perfect world, as soon as you can. And I will say the Copyright Office has some tutorials on their website that can be really helpful, that can help you DIY if you want to DIY. And the filing fee is pretty minimal. It's less than $100. So if you're, scrappy and you want to, maybe watch a tutorial or two and see if you can handle it and pay that, it's from $55 to $85, depending on what you're registering. It's so worth it because, if there is someone that copies you, you have that recourse. And a cease and desist letter is a lot stronger. If someone sees you've got a registration, they're like, ooh, I don't want this to go to a lawsuit and have to pay attorney's fees for a lawsuit, But if we do not live in a perfect world. So I think what I'll do sometimes, and I'll go broader than just a course, right? Because we coaches, especially thought leaders, we create content all the time, all kinds of content, all kinds of pins and blog posts and videos and photos. So you could live on the Copyright Office website and register stuff all day long. But a lot of times people will do a, maybe quarterly review and look back on what content did the best, which pins were pinned the most, which, and that helps you to plan your content maybe for the next quarter too. But looking at that and seeing, ooh, which of these is the most popular, because that means more eyeballs. And that means more people are like, ooh, how can I use this for myself? Mm-hmm. So maybe looking at that really key content that you're creating and saying, okay, I don't need to protect everything. Maybe I'll just protect like these key things.
Gosh, that's so interesting. It's interesting to imagine that your social media content could be copyrighted. I don't even think that entered into my awareness.
The Copyright Office has caught up. You can even captions. I mean, people basically are using captions as little mini blog posts now. Yeah. It has to be, I think the character limit is or there's a word limit of 50. It has to be at least 50 words or 150 words. But yeah, captions can be registered with the Copyright Office.
Can I register my Instagram reel of me pointing at words?
You sure can. The sound, if it's not your sound, then it might not,
Right.
you might not include the sound, but yeah.
It's just funny. It's just, I was like tongue in cheek because everyone's doing the exact same thing. And it's like, really? Anyway, don't get me started on that.
Well, and you bring up an interesting point, and Laura, you kind of touched on this before. It's like information. How much can we say that we own information, right? Because everyone's learning things from different places. Yeah. A fact all by itself is not protectable. This is why, maps are an example of things that aren't really copyright protected because it's a map. Like it's a fact that this thing is here and this thing is here. And I use kind of Amy Porterfield and Jenna Kutcher as an example. They're two, marketing mavens, if you will, and they both have a course on growing your email list. Mm-hmm. But they execute it, according to their own voice, their own brand. Their worksheets might be different. Their videos certainly are different. So it's not necessarily the top of the umbrella that's protectable. How to grow your email list. How many thousands of courses are there out there on how to grow your email list? It's more how you do it and how you use your voice and the intellectual property you created that's tailored to your brand.
Okay. Interesting. I have so many specific questions because anecdote time. I'm telling the story with keeping it very vague, but there's somebody who enrolls in every course I ever make. And this person is also a coach working in the exact same space that I'm working in. So I can only assume that they're seeing what I'm doing. I don't know. I've never bothered to track down her course to see if it's an exact replica of mine. But like, how exact of a replica does it have to be? Like word for word? It's like a plagiarism thing.
So the standard is confusingly similar, which is really a squishy legal term. So we'd have to look at, okay, the facts by themselves, this is not what's protectable, but the order in which you present the facts, that's something that's protectable. The text and the words that you use. I feel like recipes are a good example. And I don't know how many of your, how much of your audience gets into food and things like that, but ingredients, like an ingredient list, that's not protectable. It's pure fact. Here's what goes into this dish. Even instructions, just bare bones instructions, add a cup of this to this, also very factual. But when you weave in maybe some advice, some alternatives, maybe the story of where this recipe came from, once you get into that stuff, more than just the bare bones, then you get into what's protectable there. So again, maybe the sequence that you've presented the information, and of course, all of those other little creative aspects of it too.
I think that's really useful for our audience, to be honest with you, because I feel I don't touch recipes with a 10-foot pole. I never will, but other people do. And it's like, I came up with this really cool protein ball thing, but all the protein balls in the world are the same. It's like dates and protein powder and things like nut butter. I don't even know. See, I don't even know. And I think people worry. I remember when I was in nutrition school, one of my teachers said that as long as there were 2 or 3 changes to the ingredient list, you were good. It was this really arbitrary thing. But what you're saying is, well, ingredients are kind of facts, even what temperature to put the oven and how, what order to put things in. Those are kind of facts, but it's like the sort of sprinkling of like flavor content, the story around the recipe or whatever, that seems to be the protectable part.
Mm-hmm. I have a question. Does it matter if what's being copied is something that you charge people money for versus something that's just free? Like some people have a
recipe,
a cookbook, right? A recipe book or like a membership that people pay for. And then there's others that just sort of have a free recipe blog.
That's a great question.
Yeah.
If you have created that content, it doesn't matter if you're selling it or if you offer it, as a free download. It's your content. And so people can't copy it. And I would even go a step further and say, put a copyright notice on that stuff. That's, the little copyright symbol and the year and the owner of that thing. That helps too. It helps send a message.
Yeah. Interesting.
Yeah.
This is such a cool topic we never gone into before, because creating content, creating programs, creating products, creating recipes, like creators, to your point, like health coaches end up being creators accidentally. We have to be.
We all do.
At this point, everybody does. And it sort of feels like, okay, I created something. I checked that off the list for today, but maybe taking it more serious. This is like taking it more seriously. Like, this is actually a piece of your IP now. Like, you put that out there. I always think, like, if I were to look back on every blog post, every Instagram post, every Instagram stories rant I've ever done, like that's thousands and thousands of pages of a book, theoretically, So for me, this puts some intentionality behind content creation, not just like, there, I did it, I put my face on Instagram because you're supposed to. It's like, I wrote a thing, it came from my brain. I think there's something really interesting in that exercise.
Yeah, absolutely. And also too, I mean, I could talk about social media and this aspect of it, but it's like, don't just put it on Instagram, especially the really good stuff, because your account could be gone for some crazy reason.
Yes.
And so, the email lists and not forgetting about email, and this is not at all legal related, but it's your IP. And so making sure that really good stuff, the really juicy stuff, isn't just living on your Instagram.
That's a good point. That's a good point, because let's say you put it you write it in your Instagram caption, then you decide to make a blog post about it. Whatever happens to Instagram happens, but like, in some ways, well, not really. The blog post is like date stamped. So is Instagram, for that matter, but it kind of lives in your owned,
on your domain name and in a piece of the internet that you control.
Yeah. I think that's awesome advice, by the way, just for content marketing perspective. But maybe it also makes it easier to keep things in a container that is yours. And maybe, I feel like for me, chasing down old Instagram posts that did well and, I should copyright that, seems like something I'll never do. But if it was in my blog, I might be more inclined to do that.
Yeah. So from the standpoint of copywriting content, it comes down to the specific piece of content, or do you have the ability to copyright anything that appears under your sort of domain, like a website or, could you speak to that a little bit? Because it sounds to me like you're right. I mean, if someone really wanted to literally copyright every piece of content they put out there, they're going to live on that.
Yes.
Wow. Versus copywriting kind of anything that is somehow attached to your identity. I mean, I don't know. Is that a thing?
So it's a thing. You can, I don't remember the limit, because there is a limit to how many, blog posts, let's say, you can do in one application, but you can do, depending on how many blog posts you have, you can do like 6 months worth of blog posts in one application. There's specifically a type of application that applies to photographs and registering a ton of photographs together in one application. So you're not paying a filing fee times 100, But yes, and in terms of a website, maybe you don't have a blog, maybe you have a YouTube channel and your website is kind of more, you've got your lead magnet, you've got whatever you have. It's more of a landing page. You can still do, screenshot the website. If you have a video there, you can upload the video to your freebie, all of that, and kind of upload it into the system as, your website. And that's the protectable work there.
Awesome.
Well, how does a person go about uncovering or discovering if their stuff has been yoinked? Is it just by accident?
Sometimes it's by accident. Sometimes it's people who just don't know the rules. Mm-hmm. And you would be surprised, or maybe you wouldn't be surprised at people that don't know the rules. Posting a screenshot of something and then giving credit and tagging the original, I'm not talking about sharing on social media, like with the little paper airplane. I'm talking about you screenshot someone else's thing, you upload it to as if it were your image, and then tag like original post by so-and-so, way down in the caption. I know a lot of people that find out about infringement that way.
Wow.
Especially photographers, because that's their, your photographs are your thing when you're a photographer. And for many others too. But, so it depends. Yeah, there are different ways. You can do Google image search to the extent you've got an image. But sometimes it's word of mouth and someone saying, hey, I saw your stuff over here.
Okay.
Yeah. I think as coaches get more and more adept at creating content and finding that something's really resonating, and I really want to lead into this and kind of get more specific and own this space, it gets more and more important to protect that. So I love that.
Keto, carnivore, paleo, AIP, SCD, low FODMAP, so many diets, so much confusion. And if health coaches are having a hard time keeping up, imagine how clients must feel. To make sense of it all, Primal Health Coach Institute partnered with registered dietitian and health coach Martha Tettenborn to create a comprehensive functional therapeutic diet specialist certification. This flexible online course dives deep into the many different types of therapeutic diets. You'll learn the purpose of each of these diets and how to help your clients map out a nutritional plan to resolve their specific health issues. As a certified functional therapeutic diet specialist, you'll help people reach a deeper understanding of food as medicine and transform their lives for the better. Find out more at primalhealthcoach.com.
So someone goes into health coaching, they get their online business or face-to-face business, doesn't really matter, right? They sort of get it up and running and they start working with clients. Huge area of insecurity for a lot of coaches in terms of, first of all, protecting themselves from a liability point of view.
Yeah.
And also just protecting their business, coming across as professional and kind of, so I would love for you to speak to people kind of, what do they need to have in place from the beginning? And what can they sort of grow into in terms of protecting their business from liability? And I'm going to stop there. I'm going to stop putting words in your mouth.
Sure. So when starting out, I know just from experience that contracts and even like thinking about using a contract, people just get tense about it because you think you need a 10-page document and you think it's going to turn people off. I just did a post about this the other day. You think it's going to turn people away. You think clients will be intimidated. You don't want to use something when you don't even really understand it yourself. And so I understand, I preface by saying, I understand that everyone's not going to run out and start using a contract. But if I can offer like a little mindset shift when it comes to that, because like you just said, Laura, covering yourself, making sure you're protected in a different way. You've got it, aside from your content, now it's your business. Now it's your liability, right? Mm-hmm. And so a contract is there to make sure that everybody's on the same page. That's really it. Everyone's on the same page in terms of what services you're going to deliver and when, maybe when you're going to be available for communication, what you should be paid and when, what happens if somebody needs to cancel or wants to cancel, or there's a client who's really difficult to work with or harassing, or how do you handle that? So making sure that if you're not going to use an actual contract, making sure that the expectations are clear, preferably not in like a DM or a Voxer setting, somewhere that you can refer to easily. But yeah, that's why the contract is there, right? To make sure everybody's on the same page for that stuff.
Yeah. Yeah. And I like how you describe it as like, it's not just this document that the client has to sign because it protects the client. It's almost like these are the expectations and the parameters around this coaching relationship. And I think it protects everybody. It also just sets the sort of expectations. Like, this is what happens if you don't show up. This is what happens if you don't pay, that kind of thing. Mm-hmm. Yeah. Okay. So people starting out, back to Laura's question. So they need a contract. We would call that maybe like a client agreement, same thing, kind of thing. Yeah. Okay.
Yeah.
What else do they need? So they're probably going to get a website set up. So is there like, what are our website sort of essentials?
Mm-hmm. So website, especially when you're talking about health coaching, right? Or anything health related, you want to make sure and have a disclaimer. And even in the one-on-one client work too, like, I am not your doctor. Make sure and check in with your, whomever you choose as your healthcare professional before starting a new exercise regimen, before starting a new diet regimen. Something that, again, covers you, protects you liability wise, to make it clear that this is for educational purposes, but you should always check in with your trusted healthcare professional. So having that disclaimer on your website too. Also, in terms of website, a lot of people are really surprised to learn this, that you can use the TM symbol even if you don't have a registered trademark. So kind of if you're a personal brand, using it, on the banner of your website next to your name or whatever your brand name is, using that TM symbol.
Really? I didn't know that.
Mm-hmm. Yes. I love this moment because so many people don't know that. Yes, you absolutely can. It's the R in the circle that you can't use unless you have a registered trademark. But a lot of people don't know the difference.
Yeah.
So they see the TM and they're like, ooh.
What are the parameters around that? Because I have a tagline on my website: achieve an effortless relationship with food. It's not exactly cutting edge string of words, but I've been using it for like 9 years. Could I put a TM behind it? Then people would be like, oh, that's hers. Kind of. Oh, that sounds fun. I might do that right away.
Yeah. It feels very official to do it.
It does. It does.
Yeah. So, and here's the other thing that comes up sometimes in terms of like just kind of coming back to contract for a little bit. The other thing that comes up is a waiver, some sort of, do you think people need a specific separate sort of liability waiver, or can they be all in one document?
It can be all in one document for sure.
Okay. That way it's one thing, you have one conversation, they read one document, you don't have to have both. Because for a number of years I've been operating with both, but they're both short. I mean, it's not like they're, eons of pages long, but
a lot of times a waiver is a page ish.
I literally wouldn't know the difference between the two. What is the difference?
The waiver is kind of, we're not responsible for, injury or things like that. Whereas the contract, which can incorporate, and oftentimes, if I'm writing something like that, I'll just incorporate it in there. But the contract is touches on more things like the cancellation, like the expectations, all that.
Okay.
Yeah. Yeah. Like I use my waiver to make double sure everybody understands I'm not giving medical advice, that that if we're dealing with some sort of medical issue and you don't tell me, right? Yep. If I know someone's working with a condition, we need to make sure that any changes you make are communicated to your doctor, because it could impact the treatment protocol that he or she has put you on. Yep. And also indicating too that, at the end of the day, this is coaching. Again, a big chunk of my own sort of liability protection is I'm not operating in any way that I feel would be risky to anyone. I'm not putting anybody on a specific diet to treat an illness.
Right.
Not, so to a certain degree, there's a level of protection because I do my best to operate in a relatively risk-free space. But, it's a litigious society, There was one lawsuit, I think it was in Canada. And I think in this case, it was a dietitian. It was not a health coach, who had somebody, type 2 diabetic, who passed out behind the wheel of a car due to low blood sugar levels. And it was the dietitian who was sued because the person driving the car felt the reason he passed out was because of the diet she put him on.
Oh boy.
Oh, dang. That's so interesting. That's an interesting story. I was sort of amused when we were talking about the disclaimer. I'm not a medical professional. Please consult your medical professional before you start any new diet change. Like, you hear that all the time. I've probably heard that in my fitness, and for sure my fitness career. Like, oh, before you start an exercise program, consult with your physician. Like, really? Really? Are people really doing that? But I guess I shouldn't.
So here's one live example as to why that's important, because I owned a CrossFit gym for a number of years, a good 10 years. And there was somebody who joined our gym with a pacemaker, and he did not tell us that this person had a pacemaker. He didn't tell us. And he went into a typical CrossFit workout, very high intensity, and his pacemaker did what it was supposed to. It shocked the hell out of him when his heart rate got too high. Wow. So this was the pacemaker being like, stop your heart rate. So he was not injured. It was his pacemaker doing what it was supposed to do. but it's, we called an ambulance. We didn't know.
Well, I'm thinking about a guy. Yeah. There was a guy in a hot yoga class who passed out because his blood pressure meds or something couldn't handle the heat. So I feel like I don't want to make it sound like I'm disparaging the medical disclaimer, but it's sort of like for people who have diabetes, heart disease, pacemaker, you have these medical conditions, very wise to consult your doctor. But like for Gen Pop, it's like,
right.
Probably not going to the doctor and saying, is it okay if I start exercising? I don't know. Anyway, that's just a personal aside.
What the disclaimer does, it puts it on them. It's not up to you to ask what's going on here.
Right.
Oh, interesting.
That's a good point.
But it changes the responsibility.
Okay, that's interesting. So as long as we have it there, okay, we have the disclaimer. We say, consult your doctor. So now this type 2 diabetic comes to work with me and I put him on a low blood sugar or blood sugar balancing diet. And he passes up behind the wheel of the car. I hope this never happens. I'm just going to knock on some wood.
Yeah, really.
I did my part by encouraging him. But I mean, in good faith, maybe the coach should say, hey, did you follow up with your doctor, your diet? We should probably follow up. I think there's probably some just good customer service to be had there.
In writing.
In writing.
I mean, to your point, it puts the onus on the client because we're not medical professionals. And there are going to be circumstances that are just beyond our sort of scope of practice that we might not be aware of. For all I know, this dietitian had put this client on a diet who was also on metformin. Mm-hmm. And really, it was the fact that this client was on metformin and didn't contact his doctor saying, hey, I'm no longer consuming 300 grams of carbohydrates anymore. I'm consuming 100. Do I need to change my medication? Right. Yeah. So the disclaimer, I think, goes a long way of making sure our clients know that I can't possibly foresee every possible health consequence. Absolutely. So it's have it there. And look, I think the more health coaches can continue to support clients to advocate for themselves with their doctor, the better.
Absolutely. Absolutely. And I think too, going back to the expectations and setting expectations with your contract, a section on communication and how imperative, just in terms of having a successful relationship and achieving success with a health coach, number one, but also communication. I want you to communicate with me how you're feeling, any medical condition that comes up, anything I need to know that will affect the success of what I'm going to help you to achieve.
Yeah, that's a great point. I feel like that's a really great point because sometimes we put these things into vacuums. Like I've got to get my this sorted out and my that sorted out, and I got to get my contract and my disclaimer. And it's like, this is all part of your offering as a coach and encouraging, kind of Laura's point, like patient advocacy with the doctor, open communication, like, hey, I'm not a medical professional, but I would really love if you kept me in the loop on all the goings on that are happening with your doctor, just so I can know. It really sets the tone for the coaching relationship. I think it's really nice to zoom out and look at all of these must-dos in a coaching practice as really being part of the ultimate goal of really truly helping people in a way that makes sense.
Yeah.
Awesome. So contract/waiver, mostly so that everybody's on the same page and we can take the sort of liability and onus off the coach, assuming that we're staying within scope and placing it on, at the end of the day, you're responsible.
Yes.
Choices and communication and all of that. And look, I just think that should be a no-brainer. And because this comes up too with clients, do I need to go buy insurance? Like liability or I know that's not a legal question, but it's certainly, I think if you're working within a scope of practice and you have a decent liability, not just the waiver, but having a conversation with the client about what it means. Be open about it. It's not as though you're going to don't shove it under the rug and just be like, oh, by the way, you got to sign this. Make sure they have questions about it, discuss it so that they understand the role. That right there is likely going to cover 99.9% of any issues. Do you have an opinion on that in terms of professional liability insurance?
Yes. First of all, I think what you just said is great advice. We're not slipping anything under the rug. We're not hiding the ball by sending them a contract. You want them to understand this is how it's going to work. But in terms of liability insurance, so a lot of times I get this question with that goes hand in hand with, should I form an LLC or should I just get insurance? My answer is usually both, especially especially when you're getting into health, a lot of times I tell, depending on the nature of someone's business, do you have to form an LLC right away? Maybe, maybe not. With what health coaches do, what an LLC does is it separates you as an individual and anything you own as a person, like a house or a car or whatever, anything of value, from your business. And so if, knock on wood, there's ever a conflict and someone is coming after your business with a lawsuit or whatever, a claim of some kind, then so long as you're doing, whatever your state requires you to do, you're filing your annual renewals and that kind of stuff. You're not going out to dinner on the company cards and you're separating church and state, right? Doing everything you're supposed to do. Then if someone sues your business, they can't go after your personal assets. And so how insurance plays into this is, yes, it's great to have insurance. Insurance has limits. So if your limit is $1 million and someone sues you for 2 million, then there's still that gap. And so an LLC is there to, again, make sure they're not taking that million or trying to take that million out of your house. They can only go after the business.
Yeah, that's a great segue into kind of business structure. So do you help clients with that and helping them determine from kind of where they are on their business, what kind of business they want to run, what kind of business structure they should consider? LLC comes up a lot. At one point, do you think that's really important compared to a sole proprietor and just helping people understand, I guess, various structures? So if you're one person running the business compared to, hey, I've grown and now I have employees, and what considerations you think from a legal perspective people need to have as they grow?
Yep. Yes. A lot of times this can vary state by state because taxes can play into it. And so, it can be kind of state specific. But, sole proprietorship is just you, and there's really no difference between you and your business. And so that structure that I just explained where, there's your personal assets and your business assets, it's all together. And so that's the sole proprietorship. There's no real liability protection there. You can still get insurance and have that, at least have that level of protection. But it's all one with a sole proprietorship. Same thing with a partnership. And again, some states have limited partnership, which can be a little bit different, but in general, a partnership is basically a sole proprietorship with two people. And you're responsible not only for your own actions, but for your partner's actions too. And so I pretty much always, I say, with an asterisk, because I don't know what people's tax situations are, but if there's more than one person, you really want to think about the LLC structure, because then you've got the liability protection and you each have a duty to basically work in a way that is in the best interest of the business, and a duty of, honesty and fairness and all these other things that affect your business. And so I'll say in 12 years of practicing law, I think I've done one corporation. A lot of people just gravitate towards the LLC because you have that liability protection. And LLCs are a little bit more flexible than corporations. You don't have to have, meeting minutes and a treasurer and officers and LLCs are a little bit more, they offer that protection while still being flexible, and you can, kind of structure them the way that you want to.
Yeah. I incorporated. And wow, I don't know if it's different I'm in Canada, so I don't know if it's different probably, but I have this like physical binder that I have to bring with me. I don't even know what I'm supposed to do with it. Anyways,
what made you decide to incorporate, Erin, and how long ago was that?
It was probably 5 years ago, and I'm admittedly not smart about this stuff. Probably nobody is, truthfully. And so a friend of mine who is a bookkeeper for small businesses, I was kind of quizzing her up, like, which one of these should I go with? Because I was just doing this whole proprietor thing. And I thought, well, maybe I should make this a little bit more, official. And she suggested it. And I was like, okay, sounds good. I don't even know if LLC is a thing in Canada. I think it must be. But anyway, I incorporated it. She's like, here's your binder. You have to keep this. I was like, a binder? This feels so archaic. But I'm supposed to keep meeting notes and I'm supposed to keep, I don't have meetings. I'm one person. There's no meetings. I don't know what to put in this binder. It's very goofy. So I don't know if this is an out of scope question, or maybe it's just we can have a discussion amongst the three of us. But whenever we get into the topic of, and I think it's really important that we talk real about this, like here's where insurance kind of, insurance will get you this far. Your LLC will get you, will protect you the rest of the way theoretically, if and when you get sued for $2 million. Right. And people are like, wait, that can happen? That can happen in health coaching? I mean, because the scope of practice for health coaches, we're automatically protected as long as, no, we're not automatically protected. Please don't take that as verbatim. But what I'm saying is if we're operating in scope of practice, we're not suggesting anything crazy. We're not suggesting medication changes. We're not telling them to do, we're telling them to sleep more, eat whole foods, take a walk. Like we're keeping it real simple. And so it seems unlikely that someone could get sued for 2 million, but it's not impossible. And I know this 2 million thing is just something that kind of stuck in my brain. Anyway, the question that comes from this is, in your opinion, what can coaches do in their day-to-day behaviors to make sure they're not running the risk of this? Probably it's in the waiver, probably it's in the contract. All of those things are the things they're doing day to day and operating in scope of practice. Is that, I mean, I don't want coaches to feel like being sued is a really imminent threat, but I mean, it could be if they're being goofy, right?
It could be if they're being goofy. It could be if they're being careful. I mean, I don't want to sound alarmist at all, but you can be the most careful. And this person with the car accident and the dietitian or whoever it was, like, who can we sue? Who can we pin this on?
Right.
But that's where the contract is there to help you, because if that happens, you're like, hey, here's what this says. You're supposed to tell me when you're feeling, how you're feeling. You're supposed to keep me up to date on anything that doesn't feel right, any medical conditions. And, this is what you're obligated to do. So even if, knock on wood, a lawsuit comes, it's like, here's what this says. Like, I'm very sorry that this happened, but it's not on me.
So I used to watch a lot of Judge Judy. And like in Judge Judy's realm, if you scribbled this out on a napkin and the person signed it, it counted. So the question that comes from this is, we encourage our clients, our students, to create their own client agreement, because it's going to be really specific to kind of what kind of coach you are and what your expectations are of your client. Does that need to be vetted by a lawyer? Does it need to be a legal document, or can it be a self-written document? What's your advice there?
It can definitely be self-written. I've seen many self-written contracts. It's binding for better or worse. So just make sure that you know what you're saying. I mean, sometimes people will just pull things from the internet because they think they know what it says, but it might not actually mean what they think it means. So, but know that it doesn't have to be, it doesn't have to have legal jargon. It doesn't have to be 10 pages long. It's binding for better or worse. So know what you're saying when you're putting something like that together. Again, in a perfect world, probably at some point you should have a lawyer look at it. Someone in your, in your jurisdiction, and that's the best way. But what it comes back to is just know what it says and make sure that you're actually saying what you think that you're trying to say.
Mm-hmm. There is something like, because legal, like certain words mean certain very specific things that I think in the real world we take as synonymous. Mm-hmm. Isn't necessarily true. So, I mean, when I first started, and I really was, I just built my own, but it wasn't until I was like, okay, I'm going to put my big girl pants on, and this is an actual business. Then I'm going to have an actual attorney that understands the state laws here. Look at this for me, or perhaps just sort of write my own. So if you wouldn't mind, share with our audience how people, like, what do you bring to the table for people in your profession? So explain to us kind of how you work with people, at what stage of their sort of professional life do you really kind of step in to help work with people? Could you share that with us?
Sure. So I have this program. It's called the Legal Apothecary. And what it is that we'll do kind of a business wellness check, if you will, when we start. And so I will look at your creative process, the different ways that you're making money, whether it's one-on-one work, whether it's with a course, whether it's being an affiliate or using affiliates, any brands that you have, your main brand, any other trademarks that you're using, your contracts, your, terms of use and privacy policy and all of those things, and kind of do an audit of those things. And then look at where I think you might be a little bit vulnerable, or where things might not be present at all, where things might need a little boost. And my goal with this program is, you're ready to launch something new in January or next quarter, and you want to focus on that stuff, right? You don't want to focus on the legal stuff, but in the back of your mind, you want to make sure that, the expectations are clear with a client or a student. You want to make sure that you're protected from copycats. So this allows me to do what I do in the background and make sure you're protected in all of those things. And you can focus on the fun stuff.
Oh, so you do it for us?
Yes.
Oh. So is this like do people is it like a retainer thing that people pay you, or is it just sort of like hey, I'm paying for my annual checkup, or how does that work?
So it's a for as long as you need it. So it's a flat rate every month, and we would tackle one big project a month. And then with that is kind of unlimited Q&A. So if you have a question, I'm on Voxer, you can email me, whatever, little things that come up. Hey, my client wants to change this sentence in my contract. Would that be okay? What would that mean? Or, I'm doing whatever it is, like little questions that come up, I'm there with unlimited Q&A. You also get access to, I have some contract templates for sale on my website, kind of a la carte, but as part of this apothecary program, you have access to those contracts. And then, depending on what comes up in the kind of business wellness check, we tackle one of those bigger projects a month. So it might be getting a trademark registered. It might be looking through your client contract or creating one if you don't have one. It might be getting your course terms of use in place and making sure you have some language in your maybe cart close page about refunds and or lack thereof and things like that. So, there's no minimum or maximum. I kind of recommend 3 months so that we can really dig into some of the big things that areas that you might be vulnerable. But you can drop off and drop back in. But it's a flat rate each month for as long as you're in the program.
I'm just endlessly grateful for folks like you doing this work. Honestly, anytime we have somebody on the show who's in the legal space or even the finance bookkeeping space, I get really excited because personally, I don't thrive in those arenas. It's like, I just want to be the creator. I just want to be the coach. I don't want to do that stuff. And I think a lot of people probably can relate to that. And then we have this failure to launch scenario. Like, I don't want to start if I don't have this stuff. But I don't want to do it. So I'm just not going to start. And I always wonder how many people are stopping themselves from starting because the administrative bits and pieces feel completely overwhelming and in a foreign language.
Yeah.
So I'm just eternally grateful. Like when folks like you come on and use regular language with us and make it sound easy and absolutely gettable. It's just so important. I'm really grateful for that.
Thank you.
Now, just going back to this regional thing, so you're where you are. You're in Nashville. Yes. You understand law generally, and you understand the wording generally and contracts generally. But then there is this regional component, right? So how do we factor that in?
So copyright and trademark law are kind of federally protected. So I can take on clients throughout the U.S. when we're talking about things like terms of use and doing business online and protecting your content and protecting your brand. The LLC and kind of entity formation, that needs to be handled by somebody local because of taxes, because of different structures in different states. Now I'm licensed in Tennessee, Michigan, and New York. But outside of that, I can make referrals and make introductions.
Okay.
So terms of use, that I see that all the time. Is that like if you have a website, you should have a terms of use? Or is it if you've got a program that you're selling, you should have a terms of use? Could you explain what it is to our listeners and who needs one?
So terms of use.
I don't have one.
Terms of use are a contract between you and the user of your website. So, so you might have terms of use for your website. Let's say your website itself is a blog, or even maybe you sell digital products on your website or physical products, whatever. So the terms of use governs your relationship with the user of your website. Sometimes if, I'm trying to think of an example, if you're selling digital products, there might be special terms that speak to those digital products, like ownership of the IP, like these are for your personal use only, not for commercial use. In other words, you can't use these and sell them. Things like that. A privacy policy is a little bit different. That just speaks to the data you're collecting from users, whether it's, data that they know they're providing you, like their email address, or Google Analytics tracking type information. So what you're collecting and how you're using it. So that's the privacy policy aspect. There was a thing called the GDPR in 2018 that everyone was just like upside down about. And that changed the game a little bit. You have to be more clear. You have to provide, the user needs to give consent when you are collecting their information. The easy way to kind of do that is to put it right where you're collecting an email address, that your information will be used by us. It won't be sold. I'm assuming that nobody is going to be selling their email list. But and then having the double opt-in, which some marketers don't like because it makes it harder for those emails to get delivered. But I mean, I think it's a good practice because if there's the double opt-in, they get the email to confirm. Yeah. They're confirming there's their consent, right? So,
yeah, I think that the GDPR thing is interesting because if they have to click twice, they really want to be in your email list. That's how I view it. Like they didn't just kind of download my freebie and then bail. They clicked another thing. And so, yeah, there's a lot of moving parts. Hey, boy.
Yes.
Right. One step at a time. So you've got a place where people can find you, the legal apothecary that is like just a flat rate and you're tackling whatever it is they need on any given month. Right. But you did say you have some kind of templates that people could buy. So if I was a brand new coach and I'm like, I kind of need a contract and I feel like that's the one thing I need before I can really get started and feel comfortable, you've got a template that they can download, right?
So I don't have a one-on-one client contract yet. I'm working on it, but yes, I have, I do have terms of use and privacy policy templates. I have intern agreements because some folks are bringing on intern, especially as like a step one before growing their team. Independent contractor agreement if you're bringing on contractors, podcast guest contract. What else am I forgetting? Other things that kind of pertain to that infopreneurship, that doing business online. So I've got a set there. NDAs I have. So there are some things, but a coaching client agreement is definitely on the list for 2023.
Awesome. Amazing. Cool. Where can people find you? Because we've got people at all various stages of business and some people that likely have reached an area where they really need to grow and legally they don't know what they need to grow into. So, let people know where kind of they can find you to make sure their house is in order for that growth they're looking for.
Yeah. So I'm on Instagram all the time. My handle is Hey So Maria. And you can find me there. You can find me at my website, which is spear-ip.com. And that's where I'm hanging out.
Amazing. Oh, I love this kind of conversation. I love feeling comfortable about it, but I always like being brought into a comfortable place. And so I'm, again, grateful.
You guys ask great questions.
Well, we've been there, right, Erin? I mean, we've been at various stages and we know what we hear from, our students and graduates and kind of what they ask us that we're like, we're not lawyers. Right.
Well, yeah. I mean,
ask Maria. Maria's a lawyer.
It comes down to sort of these pain points that are consistently brought up to us as health coaching educators and health coaches that are really excited to get started. Like, I want to do this and want to start helping people. And then there's all this business stuff that they have to set up. And like I said earlier, it overwhelms people to the point of inaction. And we don't want that. We don't want inaction. We want more health coaches. So we're happy to ask the questions that we know our audience is thinking.
Awesome. Thanks again, Maria. This was really great.
Thank you so much.
This podcast was brought to you by Primal Health Coach Institute. To learn more about how to become a successful health coach, get in touch with us by visiting primalhealthcoach.com/call. Or if you're already a successful health coach, practitioner, influencer, or thought leader with a thriving business and an interesting story, we'd love to hear from you. Connect with us at hello@primalhealthcoach.com and let us know why we need to interview you for Health Coach Radio. Thanks for listening.